Well, as far as the recent bill approved by the cabinet with respect to curtailing the Chief Justice's discretionary powers is concerned, I think the same is a manifestation of the growing differences and the growing tensions between the executive and the judiciary. We have seen throughout the tenure of this current PDM government that the government has often been embroiled in a conflict with the judiciary, and at different points we have seen the government express its concerns with respect to the constitution of benches and with respect to the allocation of certain cases, certain politically consequential cases, to specific benches and specific judges. Now, as far as the legality of this decision is concerned, Article 191 allows the Supreme Court to formulate rules to govern its internal procedures. Nonetheless, Article 191 gives such discretion to the Supreme Court subject to the Constitution and the law. So there is no cavil to the government introducing a law which regulates or perhaps even restricts the Chief Justice's discretionary powers to constitute benches or initiate suo motu cases. Because as far as Article 184.3 is concerned, it does not mention Chief Justice. It mentions the Supreme Court, and it is through the Supreme Court rules that the Chief Justice has been vested with the power to initiate suo motu notices. But the problematic aspect of this bill is that the bill gives a right to appeal in matters where the Supreme Court exercises its original jurisdiction. Now, the Supreme Court's jurisdiction emanates from the Constitution. The Supreme Court's original jurisdiction and the Supreme Court's appellate jurisdiction both emanate from the Constitution itself. So the question then is that can an ordinary legislation enhance or enlarge the Supreme Court's appellate jurisdiction? My view is that perhaps not. So my view is that while some aspects of this bill may pass muster, but the aspect with respect to giving the Supreme Court the jurisdiction, the appellate jurisdiction, the jurisdiction to hear appeals in matters where the court exercises its original jurisdiction, that matter perhaps may not pass constitutional muster. And I believe that in the next few days we may see this matter, this law reach the Supreme Court, and we are perhaps going to see a situation where some provisions of this law may be struck down by the Supreme Court. Before that, however, it's also important to realize that this bill has only been passed by the cabinet. It is yet to be tabled in the parliament. So there might be a situation where some aspects of this bill may not be passed by the parliament, but given that this government comprises a number of different political parties, this bill in its present shape is perhaps likely to be passed by the parliament. And once the parliament passes this law is likely to be challenged before the Supreme Court, where in my view certain aspects of this law will pass muster, but section 3 of the law, which pertains to giving the Supreme Court the appellate jurisdiction or enlarging the Supreme Court's appellate jurisdiction, that particular aspect may not pass muster.